Good day, sir. I am Mary Grace Bernanti Valiente from Higoo City Colleges. Bachelor of Science in Criminology, Block B. Rule 112, Preliminary Investigation. Section 1. Preliminary investigation defined. When required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground, except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day, without regard to the fine. Section 2. Officers authorized to conduct preliminary investigations. The following may conduct preliminary investigations. A. Provincial or city prosecutors and their assistants. B. Judges of the municipal trial courts and municipal circuit trial courts. C. National and regional state prosecutors. D. Other officers as may be authorized by law. Section 3. Procedure. The preliminary investigation shall be conducted in the following manner. Their authority to conduct preliminary investigation shall include all crimes cognizable by proper court in their respective territorial jurisdiction. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. They shall be in such number of copies as there are respondents, plus 2 copies for the official file. The affidavits shall be subscribed and sworn to before any prosecutor or government officials authorized to administer or to, in their absence or unavailability, before a notary public, each of whom must certify that he personally examined the affiants, that he is satisfied that they voluntarily executed and understood her affidavits. B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it, or if she finds no ground to continue with the investigation, or issue a subpoena to the respondent. attaching to it a copy of the complaint and its supporting affidavit, and the respondent shall derive to examine the evidence submitted by the complainant, which he may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to respond against the respondent, and this shall be made available for the examination or by copying the respondent at his expense. Objects as evidence need not be furnished but shall be made available for examination. Copying or photographing at expense after requesting party. C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit a counter affidavit and that witnesses and other supporting documents relied upon for his offense. The counter affidavits shall be subscribed and sworn to and certified as provided in paragraph A of this section, with copies thereof furnished by him to the complainant. The respondent shall not be about to file a motion to dismiss in lieu of counter affidavit. D. If the respondent cannot be subpoenaed does not submit counter affidavit within that 10-day period, the investigating office shall resolve the complaint based on the evidence presented by the complainant. E. The investigating officer may set a hearing if there are facts and issues to be clarified from the party or a witness, and the parties can be present at hearing but without their right to examine or cross-examine. They may